If you've ever lived in a community with a homeowners association or an HOA, you know the rules can get, well, pretty specific. But what happens when a totally simple question to your HOA gets a ridiculously complicated answer? Today, we're going to dive into a case that shows how one homeowner's quest for a single invoice spiraled from a simple email into a full-blown legal hearing. So let's get into it and see exactly how this whole thing went down.
I mean, it sounds kind of crazy, right? A wall to hide trash cans. But that little structure is right at the heart of this entire mess. This is the big question we're tackling today. How on earth did something so small get so completely out of hand?
All right, Section 1, a simple question. It all kicks off with Linda Curtin, a resident at a place called The Ridge at Diamante del Lago in Arizona. All she wanted to do was build a retaining wall on her own property, and she figured the HOA might know a good contractor.
So on August 1st, 2018, she sends off this super straightforward email. It's a classic neighborly kind of request, right? Hey, you all had some work done that I liked. Can you tell me who did it? It's the kind of thing that you get a quick, simple answer.
So when the community manager said she couldn't really recommend a general contractor, Ms. Curtin got a little more specific. And this quote from her email, this is the exact moment the whole conflict really begins. She's just trying to find the name of the guy who built a small block wall at the community clubhouse. Simple, right?
Okay, on to Section 2, the records runaround. And yeah, this is exactly where things start to go off the rails. That simple question did not get a simple answer. What came next was a month-long back and forth that, really started to wear on everyone's patience. Now, this timeline just lays out the whole frustrating journey. First, the manager only knows the guy's name is Roberto, but whoops, can't seem to find his number. Then she lets it slip that the board treasurer was the one who arranged the work. By September 12th, Ms. Curtin is clearly fed up with the casual back and forth, and she makes a formal written request for the actual invoice. When that still produces nothing for months, she takes the last step and files a legal petition.
And that's the word right there, evasive. That's the word she used in her official filing to describe the whole situation. She felt like she was being deliberately stonewalled. And that feeling is what turned a simple question into a real legal fight.
Which brings us to Section 3, bringing in the law. See that formal letter Ms. Curtin sent on September 12th? That was more than just her being fed up. Nope, that was a legal move. It officially started a countdown based on a very specific Arizona state law.
Let's actually look at the law. Arizona Revised Statutes, Section 33-1805A. The language here is, it's crystal clear. An HOA shall make its records available, and it shall have 10 business days to get it done. The whole point of a law like this is to make sure HOAs are transparent and to stop the exact kind of runaround Ms. Curtin was getting.
10 business days. That's it. That's the magic number. The moment her former request went out, the HOA was officially on the clock with a hard legal deadline.
And you guessed it, they blew right past the deadline. The official response doesn't show up until September 24th. That's 12 days later. And to make it even worse, the invoice she actually asked for wasn't even in there. So now it's not just frustrating, it's an open and shut violation of state law.
Okay, so Section 4, an invoice and suspicions. After she files her official petition with the state, the HOA finally coughs up the invoice on December 10th. But instead of clearing things up, the document just threw a whole lot more fuel on the fire.
And this slide just shows you exactly why she was so suspicious. I mean, just look at this. On the left, you've got the HOA's check to the contractor, dated November 1st. But over on the right, the contractor's invoice is dated November 2nd. Think about that for a second. The HOA paid the bill a full day before they were even officially billed for it. For Ms. Curtin, this was a massive red flag.
So that weird date thing just sent her down this whole rabbit hole. She started asking some really serious questions, like, is this invoice even real? Was it forged? And what about the contractor, this Gualberto Castro guy? Was he even licensed for this kind of work? And maybe biggest of all, where's the approval for this $1,000 project in any of the board meeting minutes? Suddenly, this wasn't about a garbage can wall anymore. It was about whether her HOA was operating by the book at all.
All right, Section 5, the judge's final ruling. Everything comes to a head at a hearing on February 20th, 2019. Now, we're not talking about a big courtroom drama here. This is a hearing with an administrative law judge, basically a specialist who handles these kinds of disputes. And this is where everything, all the emails, the dates, the suspicions, it all gets laid out for a legal decision.
So, it really all boiled down to one key question for the judge, didn't it? Based on all the evidence, Had the HOA actually, legally broken the law?
And the answer from the judge was a simple, straightforward yes, they had.
So that's it, right? Case closed, total victory for Miss Curtin. She was right, the HOA was wrong. Well, it's never quite that simple in the legal world.
The real answer is not exactly. It was a victory, but a very, very specific one.
And this chart here breaks down the judge's logic perfectly. The HOA was found guilty of one thing and only one thing, violating that 10-day records access rule. All those other concerns Ms. Curtin had, the potential forgery, the contractor's license, the missing board approval, the judge basically said, look, that's not what this petition is about. The case was strictly about access to records. So on that specific technical point, she won. Everything else was deemed irrelevant to the case at hand.
So what was the final scoreboard? Well, as you can see, her petition was granted. The HOA got officially cited for violating that Arizona law. And the financial penalty? The HOA had to pay her back the $500 she spent on the filing fee. A win for sure, but a narrowly defined one.
Okay, last section. What every homeowner should know. So after all that, what can the rest of us actually learn from Linda Curtin's long fight for a single piece of paper? Well, it turns out her story is basically a masterclass for any homeowner who has to deal with an HOA that's being less than transparent.
It really boils down to this three-step playbook. First, put it in writing. A formal email or a letter creates that paper trail and, more importantly, it starts the legal clock. Second, name the law. When you mention the specific statute, you show them you're not just a complaining resident, you're someone who knows their rights. And third, and this is probably the biggest lesson from this whole saga, keep your complaint laser-focused. Ms. Curtin won because her case was about a technicality, that 10-day rule, which was easy to prove. All her other suspicions, as valid as they might have felt, would have just muddied the legal waters.
And that really leaves us with this one last question to think about. The judge in her ruling actually said she hoped everyone could move past this and cooperatively build a better community. Miss Curtin won her case, she got her $500 back, but the whole thing took 6 months and probably caused a lot of bad blood. It just makes you wonder, in situations like this, is winning in court always worth the fight?